Speaker, sir, I request to move that Bill number 17 of 2023, the Goa Legislative Diploma number 2070, dated 15/4/1961, Amendment Bill 2023, to be taken into consideration.
Yes. प्रश्न असो आसा विधेयक विचारान घेवचें जे काय मान्य आसा. Explanation. Okay.
Speaker, sir, there are certain amendments to this Act. Amendment to Article number 31, serial number 1. Existing, I will tell you what is existing and what we have proposed. Why we have proposed. Existing, the affair of each Comunidade shall be managed by a managing committee elected every 3 years in a manner prescribed in this code. What we have proposed is the affair of each Comunidade shall be managed by a managing committee elected every 3 years in the manner prescribed in this code and rules framed thereunder. Since all details were not mentioned in the code, other details will be prescribed in the rules. Powers to make rules are prescribed in Article 153, bracket 19 of Legislative Diploma 2070. So, serial number 2, amendment to Article number 50. Person who have served as a member of the managing committee for 1 term may contest election for immediate next term of 3 years. The proposed is an outgoing member of the managing committee to the Comunidade shall be eligible for re-election. Now, the justification to this is to clear the ambiguity that the member can be re-elected for number of terms and not only for one subsequent term. Amendment to Article 70, Clause 1. The elected part of the Comunidade may only be dissolved by the government after conducting an inquiry in which it is proved that its performance was against the interest of the Comunidade. In this inquiry, the defendant must be given a hearing. Proposed, the elected part of the committee may only be dissolved by the government after conducting an inquiry in which it is proved that its performance was against the interests of the Comunidade. In this inquiry, the defendant must be given a hearing, provided that the government may, pending inquiry, if it is found just and expedient, suspend the committee and appoint an officer of the government to take charge of the affair of the Comunidade until completion of such inquiry. Now, just to make provision of the suspension of managing committee during pendency of inquiry and to appoint government officer for management of the affairs of the Comunidade, government may with due diligence decide if the substitute committee is required to be dissolved or not. Amendment 70, Clause 3. The members of the managing committee affected by the dissolution should not be elected before completing 9 years from the dissolution and shall pay a fine of rupees 50. Now, what on the proposal, the member of the managing committee affected by the dissolution shall not be re-elected before completing 9 years from the dissolution, and each such member shall pay a fine of rupees 10,000 to enhance penalty so as to have deterrent effect against violation of provisions contained in Article 70. Amendment to Article number 327. The plot adjoining each other and located near residential buildings and roads abutting roads, public way or village ways and paddy fields shall not be granted in impetus for cultivation within a radius of 50 meters, except strips of land of not more than 5 meters wide, which may be granted without auction and on payment of approximately furrow previously fixed, increased by 50%. Now, the proposal, the plot adjoining each other and located near residential building and those abutting road, public way or village ways and paddy fields shall not be granted in emphasis for cultivation within a radius of 50 meters, except strips of land of not more than 10 meters wide, which may be granted without auction and on payment of approximately furrow previously fixed, increased by 50%. so as to bring the provision 327 in conformity with building regulation. Amendment to Article number 334A, Landless Jonario. Landless Jonario proposal is the landless Jonario of the concerned Comunidade in order to restrict grant of land by Comunidade only to its Jonario. Amendment to Article number 334A, existing, provided also that no person or member of the cooperative housing societies, as the case may be, whose annual income exceeds rupees 3,50,000 or such amount as may be prescribed by the government, shall be eligible for the grant of land or lease without auction. The proposal is provided that no person or members of the cooperative housing society, as the case may be, whose annual income exceeds rupees 15 lakhs or such amount as may be prescribed in the rules by the government, shall be eligible for grant of land of lease without auction. The existing provision contained in the proviso has become redundant. The income limit was last amended in the year 2001. Salary has been increased, hiked 2 times, 6 pay commission and 7 pay commission. Amendment to Article number 334, existing. For the purpose of the article, the word landless means that neither the person nor his or her spouse or minor child owes a plot of land or house in the state of Goa. The word house shall be include a flat or apartment. Proposal. For the purpose of article, the word landless means that neither the person nor his or her spouse or minor child owes a plot of land or house or an undivided share in ancestral property which, on the date of making application for grant of land, has been separately allotted share either in family partition or settlement or allotted through court proceedings or otherwise in the state of Goa. The word house shall also include a flat or apartment to bring more clarity in respect of the eligibility criteria for the grant of plot of land by Comunidade. Amendment to Article 334A. This is a new one. An applicant falling under Clause 7 above shall support his application by a certificate issued by the concerned Comunidade, duly countersigned, attested by the administrator of the concerned zone, certifying that he is a Junario of the such Comunidade, to restrict grant of land by Comunidade only to his Junar. Amendment to Article number 334C, proposed. Notwithstanding any contained in this code, the government may, with the prior consent of the concerned Comunidade, grant land by way of long lease for any public purpose for such period and on such terms and conditions as it may deem fit to any government department, government undertaking, or statutory body constituted by government. This is to make provisions for the grant of land, irrespective of the area, to the government with the consent of the Comunidade. Amendment to 339A. The Comunidade may entrust the development of land to any private agency by auction and or by inviting bids subject to the approval of the government, so that it can grant subdivided plot of land as per the provisions of this code. Some Comunidades, due to weak financial positions, are unable to develop their land. The proposed amendment seeks to enable such Comunidades to get the land developed to private agencies. Amendment 339B. The immovable properties belonging to and vesting in the administrator of Comunidade in the North, Central and South Zone shall be considered as deemed to be covered by the provisions of the Goa Public Premises Eviction of Unauthorized Occupants Act 1988, Goa Act number 22 of 1988, and shall be considered as public premises within the said Act for the purpose of the said Act. This is to bring the immovable properties belonging to and vesting in the administration of Comunidade in the North, Central and South Zone shall be considered as deemed to be covered by the provisions of Goa Public Premises Eviction of Unauthorized Occupant Act 1988. Goa Act number 22 of 1988 and shall be considered as public premises within the said Act for the purpose of the said. These are the amendments.
प्रश्न असो आसा
एक मिनिट मूव करून अमेंडमेंट
प्रश्न असो आसा विधेयक विचारून घेवचें जेका जे मान्य आसा ताणें हय म्हणचें
हय
जेका मान्य ना ताणें ना म्हणचें हय म्हणटाचें म्हणणें मान्य जालां हय म्हणटाचें म्हणणें विधेयक विचारून घेवपाचो प्रस्ताव मान्य जाला आतां ह्या विधेयकाक कांय दुरुस्ती आसात सेक्शन 6 सेक्शन 7 श्री गणेश गांवकर हांणी म्हणच्यो
Speaker sir, Goa Legislative Assembly Amendment to the Goa Legislative Diploma number 2070 dated 15/4/1961, Amendment Bill 2023, Bill number 17 of 2023, as introduced in the Legislative Assembly. Serial number 1, Amendment of Clause 6, page 2 in Clause 6. Yeah, okay. So the circulated amendment is moved by me for amendment clause number 7 also, and it is before the House.
Yes, दुरुस्त्यो सभागृह मुखार आसात. Yes.
Speaker, the first objection which I would have is the amendment to Article Section 3, which is Article 50. An outgoing member of the managing committee of the Comunidade shall be eligible for re-election. आम्ही पळयतात ते Comunidade परत election बसतात and it becomes like a family fiefdom. And I think earlier when the original code was there, a person could not contest election for that same post. He could be contesting for another post. Then that was dropped and he was eligible. Then it was barred. I think you put a term of 2 years, 2 terms. I don't think you make him permanently there because there are some people like one family runs the whole Comunidade forever. So I think it is the interest of the Comunidade, of the components of Comunidade, let them not be there forever. You can put 2 terms and after that they are out. So this is the first thing. Second, in section 4 of this bill, Article 70, एक provision आहा था that during pendency of an inquiry, the government, if it is found expedient, suspend such committee and appoint an officer of the government to take charge of the affairs of such Comunidade till completion of the inquiry. This is, according to me, a very dangerous clause, and I will tell why. कोणे complaint गाय जाल्यार, the moment you conduct an inquiry, you will suspend that committee. And the problem which will happen is, a government officer will be appointed and he will run. Then he will do whatever you want or the government wants. You may not have bad intention, but can be misused. The other part of it is, Comunidade elections attanna ek effective committee asta, and there is also a substitute committee. They person elected asat. So if you have, even assuming you dismiss the effective committee, you can allow the substitute committee to come in. So why should we immediately say that even they are bad without they having taken
Speaker,
charge?
Sir, one minute. I would just give a clarification. I just mentioned actually to the Honorable the House earlier that I said government may with due diligence decide if the substitute committee is required to be dissolved or not. So we will take that into consideration.
But that's not here in the section.
No, this is what we meant.
But it's not here.
No, but we said, see what we said, the government provided that the government may be pending inquiry if it is found just and expedient. Suspend the committee and appoint an officer of the government. This we will take. We will appoint an officer only if fine. See, these subcommittees are also actually substitute committees are also actually elected by them only.
Exactly.
So we will suppose if these substitute committees doesn't have anything to do with this. Whatever the irregularities the main committee has committed, if they do this thing, then we will appoint them. We don't have that.
No.
We will look into that first.
I will explain this.
Yes.
It's like you have a sarpanch and you have a deputy sarpanch. you can disqualify a sarpanch if he has acted against the interest of the panchayat. The deputy sarpanch does not take over that post unless that is vacant or he is acting as in the absence of the sarpanch. So the substitute committee does not come into picture until that effective committee is either on leave or dismissed or suspended. So for you to say that unless they are involved, they can't be involved because they are not effectively there.
No, sir, the inquiry basically will be carried on. If we find that this committee is not a part of any...
How can they be? If they've not been given charge, they can't be part of it.
No. Whether during this process of whatever irregularities, if this committee has, the main committee has, managing committee has committed, if they are means they are not involved in that thing, so
but
they will be given a charge.
You'll have to amend this proviso.
No, but we have already clearly
it's not
mentioned
here.
that
The words are not here.
Government will decide that provided that the government may pending inquiry, if it's found just an expedient, suspend the committee and appoint an officer of the committee. But we may appoint
officer of the government, not committee.
That's officer of the government. That is afterwards. But first we will look into it. But we have not mentioned that. But we will do that.
But if it's not in the statute, you are not bound to do it. Then you will never do it.
No, it is not that we will never. Our intentions are very clear.
But then you can amend this. You can amend this proviso.
What is that?
Should be in black and white. What he's saying is correct.
You can amend the proviso.
I think we can.
Oi.
Otherwise, we'll pass it in this form. When next assembly, I will get you an amendment to that.
No, he's giving you.
Why? See the word, government may. So the word may is already used there actually. The government may pending inquiry.
No, my question is, it's not, see, your power of suspension, you're not saying you shall suspend, you may suspend. But the question is, when you suspend, then substitute committee should step in. Why a government officer? If you're saying you will amend it in the next, I have no problem, assembly. But the question is,
This will come only when there is some serious irregularities committed by the committee.
But you said that you will amend it in the next assembly.
We'll amend it in the next assembly.
Okay, I will accept that statement. But now look at the next section 8, which is sought to be introduced.
Which one?
After Article 339. The Comunidade may entrust the work or development of land to any private agency by public auction and or by inviting bids, subject to the approval of the government. Why should it go to subject to approval of the government?
The government should know what is happening now.
The administrator is there.
No.
Why you want to run the affairs of the Comunidade?
We are not.
So,
Government approval is required.
no,
We are not running the
then you are running the
affairs of the
Comunidade.
Comunidade.
The Comunidade is a private body. You can't run the Comunidade. High Court has said twice in judgments that the Comunidade is a private body. Division bench judgments are there. So you are running the Comunidade. Administrator can check. Of course, it will require approval of the administrator.
No,
but
we are not
the
running the
government.
Otherwise, also anything approval, even as far as the allotment of the plots, it comes to the government only.
Allotment is by law.
So
Article 34G says that each allotment shall be with prior approval of the government.
This is the new amendment which we have brought to this thing. So
Which
we
is
have
wrong.
said that government basically will look into it.
No. What is your statement? You will look into this provision. So,
दोन provisions because sir my select committee that दोन provision हे झाले if you are going to amend दोन पुसा हे झाले my select committee that
I never said we are looking into. I never said that we are looking into the
Just a
provision.
minute,
The provision will stand.
What Honorable MLA Kalus Babu is saying, see, it is a approval if the Comunidade is weak and they cannot have to develop, then it is the approval of the government. That is what you are saying.
no.
It is, you see, read, sir.
Comunidade is weak. It's not written Comunidade is weak.
Financially weak, that is a
We said
section
we are
of
financially weak, no.
financially weak.
339A.
Is the Comunidade financially weak?
Yeah, we said.
What is the committee, if they are unable to divide the plots and they don't have for division, powers are given to the Comunidade, but if they don't have, the auctioning of the plots has to come to the government, that's what he's saying, no?
No, this is development. Please read this. The Comunidade may entrust the work of development, not auction. I agree that when it comes to allotment of the plot, it is mandatorily to be going to the government for prior approval. That is different. That is an Article 34, subsection Article 34G, F and G. Clearly it is there in the Comunidade Code. It is requires prior approval. This is independent Article 339A.
This is introduced now, that's what he's saying, Honorable Minister is saying.
But the introduction is relating to development. It's not relating to auctioning.
No. What it means, what it is introduced, it was not there in the past. It is introduced to introduce where the Comunidade does not have the money to develop into
That's
section.
not here. If it's a poor Comunidade or a rich Comunidade, everybody has to
why
go.
this basically provision has been bought.
There's nothing there.
No, I have said why this provision has been bought, I said.
But it's not in the statute. What is you say in your statement objects is different from what is the section.
That is not in there.
No, I have said
You may
why
have
this
many
provision
intentions,
basically
but the
is
law
bought.
will be interpreted by what is the section, not by the statement and objects.
339A. It is 339A.
39A.
339A.
339A.
Bill copy there. Bill copy.
Yeah.
339A, it is there.
Yes,
Page number 3rd.
yes.
Yeah.
Subject to approval of the government. If the Comunidade may entrust the work of development of land, why should development land get prior approval of the government?
Because some Comunidade, due to the weak financial position, they are unable to develop the land.
What about the rich one?
The proposal of the amendment is to enable of the Comunidade to get
But
the
what
land
about the
developed in
rich
the
ones?
private agency.
How does this article make a difference between rich and poor?
No. See, substantially, if they want to,
There's nothing if you want to.
No, that's how you
This is
assume
if
it.
No, that's not.
This is if they want to take any private agencies basically to develop their land. So basically government basically should know what is happening in the
Why
Comunidade.
should you run the Comunidade? Why should
We
the
are not
government run the
we are not
Comunidade?
running the Comunidade.
It
but
will be.
When any of these.
I don't say you, but I will say if your successor, anybody else, will empanel his people and they will be given the development. If you don't give him, you will not approve it.
No, but development is clearly, it is clearly said by auction or by inviting bids subject to the
You
approval
can't
of
put
the
a
government.
you
So that
have
is the
to-
reason government basically will go through the thing, whether the proper procedure has been followed.
Whenever we are legislating, your intention may be good, but if the words don't show that, then please understand it will have a long-term effect of trying to destroy the Comunidade, trying to override the private Comunidades. We have to think in the long term. I'm not thinking just for one Comunidade or second Comunidade. This will be a long-term effect by which you will destroy the Comunidade. So please, I request, if you want to make this, you can say, see, whatever the Comunidade does requires administrator's approval. If the administrator doesn't approve, your Comunidade cannot go ahead. Even signing of a check, administrator signs the check. So I don't think that there should be such a fright. Why should the government?
Speaker sir, I will just correct honorable colleague of mine. Speaker sir, it is an addition to the section of the Comunidade 339A. It is only if they require to do it, they have to send.
That's not there.
No,
If
Speaker
they
sir,
require.
no, I'll read it. You read it how it is. Read it. See, I'll read it.
Right.
The Comunidade may entrust the work of the development of land. The Comunidade may entrust the work of development means that if they want to send it, we are not, government is not asking them to send. If they want to send it, they will send it. It is very clear.
They-
No.
if at all-
Yeah,
if
see,
they-
The
if
sending
at all
is-
they want.
The sending is not to the government. The may
I will explain. I will read it again.
is of the development.
Speaker sir, I will read again. The Comunidade may entrust the work of development of land to any private agency by public auction and or by inviting bids subject to the approval of the government so that it can be grant subdivided plots of the land. It is very clear.
think
If
we
they
know.
want, Speaker sir, if the Comunidade feels that they require help of a private party to develop the land, then they will decide and they will send for approval. What honorable colleague is saying, why it has to go to government, it has to go to the administrator. What difference it makes, Speaker sir?
No, I think Honorable Law Minister should be fair. This words, please read it. It goes like this. The Comunidade may entrust the work or development of the land. What it may entrust is the work or development of the land. So if the Comunidade wants to develop the land, it may entrust the development land to any private agency. And how it should be done? By public auction and or by inviting bids. Now, the next part. Subject to the approval of the government.
Correct.
What is subject to approval of the government? this entrusting of the work is subject to the approval of the government. Does it say the government will give finance, government is going to this thing? Government will never give finance to Comunidade. Comunidade is going to earn out of it.
Correct.
So therefore, why should it go for approval of the government?
No, it would have gone to the administrator, it will come to the government.
Why should it? Because an
Why
appeal
should
can
it?
come to the
Why
government.
should it? It's okay. But it is, if the Comunidade themselves decide. No,
That
Speaker
means
sir,
the government's-
this question comes only when the Comunidade themselves have to decide whether they have to do it. If the Comunidades decide to do it on their own, then the question to sending to government does not come.
No, I'll tell you one thing. If tomorrow the administrator says no, you can challenge the decision of the administrator before the tribunal.
Now also you can say it to the government.
But it becomes government, subject to the government. Government decision come, it challenge the tribunal. So therefore, I think that these are major, this thing, it's a major lapse, and I think the Honorable Minister and the government should think about it. And as far as this, I've seen a amendment to the bill. I think that this, I would not object to this, because these two amendments which are made are giving the landless children of the components of the respective community. Because I was going to mention about this provision, which landless joneros, that I think this
That both are included.
two amendments I think are proper in order. I would not be objecting to these amendments.
Speaker sir, I will again tell, Speaker sir, I will just tell my colleague.
Yeah.
Speaker sir, I will again tell my colleague, see, even afterwards the final allotments has to have government approval. So what is there if they have done it priorly?
No. Allotment is something totally different from development.
No, let us assume that what you are saying is correct.
I am correct.
No, you are correct. Let us assume that you are correct. I am just saying you are correct.
Yes, Sri
See, Speaker sir, एक मिनट सांगता था का? Speaker sir, after allotment also the government approval is required in the general condition. Yes or no, Speaker sir?
Yeah, it is
It is
compulsory,
required.
mandatory.
Then only the plots are given. So in the same way, what difference it makes if it takes approval of the previously of the government? Does not make any difference.
This is a day-to-day interference in the
Speaker sir,
day-to-day
I think I have
function.
explained it.
One and the
Understood.
same.
I
the
think
point.
this should be...
Yes, Benji Vegas.
And the reason why is, Speaker sir, firstly from 1526, as long as we can go to 1526, documented by the Portuguese, from 1526, कुमदादीचें documentation तेन्नासून कळोन गेल्ल्या. आणि the state provides only administrative tutelage to the Comunidade Code, as per the Comunidade Code. The government's move to amend the Code of Comunidade is looked at as a move to trample upon the rights of the indigenous people of Goa, their villages and their lands. This move is denounced and undemocratic as explained herein. The institution of Comunidades, though not dated, is over 2000 years old and anciently called as Gaonkari. It is based on the laws of customs and usage of the indigenous people who founded the villages at that remote time. The Portuguese codified these laws, recognized their self-governing autonomy, left them to themselves, but introduced an element of legal fiction in the fashion understood in Europe without altering their prevailing laws of customs and usage, as is evident with the Foral of Afonso Mexia in 1526. The Article 6 of the Code of 1904, Article 5 of the Code of 1933, and Article 5 of the Code 1961, read with the preamble of the Code dated 15th of April 1961. Whilst considering the rights of self-determination of the indigenous people of Goa, we have to also consider the Native Title Act 1993 of the Commonwealth of Australia, which is an outcome of the judgment called as Mabo, that is two judgment of the High Court of the Commonwealth, where the wrong of the Aboriginals was written in the similar manner as in Code of Comunidades 1961. The recourse for amendments of the code is by way of Article 652, Speaker sir, हे 1526 2000 शेंकड्याचो कोड वो हेजी जो अमेंडमेंट हाडटो जाल्यार आतां जे आम हाडूं सोदताय that has to be brought by in means of article 652 of the said code, which is not been done in the right manner. This must be understood that the Kumdads, in spite of being owners of over 75% of the legislative assembly, and that the state provides only administrative tutelage incumbent on its being a major stakeholder. Such administrative tutelage cannot be misused to carry out amendments. Ye je administrative tutelage dilliya through the Kumdad code, we are now misusing this. Ami amendment amcha neshkon hadpa jaina legislatively. This is not the right format. We have to go to the article 652. Ye mudo jaina ki aaj hum hattay ani hal tum challenge kore. This is not good legislation, Speaker sir. This is a wrong way of legislative and bringing in an amendment. You're bringing in an amendment to a code, which you go to the court, you will have to lose in court. And then you cannot say to a legislator that you will go to court. So giving administrative tutelage cannot be misused to carry out amendments. When the convention under Article 652 was convened and the sessions of the said convention to be conducted have not been completed. To me, as per Article 652, a convention was called. And titu olop zalle. But it was not completed. Te complete zalle na. And the government is duty bound to duly hold the sessions of the convened convention till their conclusion. Speaker sir, this is the major fault of this. And that is the reason we have to oppose this and we should not allow this to be passed. It is prayed that the government may observe the dignified honor of the state legislature not to proceed with the proceedings on the proposed amendments. The bill is being hurriedly introduced without completing and without giving due diligence to Article 652. No consultation to the Kumdads and the Kumdads across Goa was taken, and Article 652 was not completed. With regards to this, I strongly put my foot down and would request you not to propose and not to get this amendment cleared, and would like to put it forward to the select committee with all the irregularities that are there within this amendment, Speaker sir.
Yes, sir.
Speaker sir, बाप काल्लूस आणि बेन्झी हे कोमुंदादीन चड असोसिएटेड आनी तांणी बाय रुल्स तांणी सायड केल्ले आहा कित्याक हें तें पूण मुखेलमंत्र्याक हांव इतलें सांगूंक सोदतां तो इतले ताकतिकेन आहा की हें बिल इंट्रोड्यूस जावचे पयलीं आज पळय एडिटोरियल आयलें क्लियर अटेम्प्ट टू सीज कंट्रोल ऑफ द कोम्युनिदाद हें आयचें एडिट पेपराचें पास पसून करूना आमी तुमी म्हाका दिसता तें अपलोड केलें ताजेर ऑलरेडी पब्लीक रिएक्शन हें सुरवात जालां हें म्हणटात द गोवा लेजिस्लेटीव डिप्लोमा नंबर 2070 अमेंडमेंट बिल 2023 when passed will allow the state government to mediate directly into the affairs of the Comunidade, giving itself sweeping powers that will eventually strengthen its stranglehold over the age-old institution. Speaker sir, अशेंच जाता हें एडिटोरियल पेपर बी वाचना दिसता तूं ह्या दिसांनी तूं फकत फुडली पेज पळयता आपलो फोटो हें एडिट म्हणटा की तुमी आतां लास्ट कितें उरलां तें बचको मारतात म्हणा तो कोमुनिदादीचेर बचको तुमी मारला म्हणून स्पीकर सर आतां सेक्शनां जर वाचलीं अमेंडमेंट तुमी कसो हाडटात लास्ट अमेंडमेंट 334C पळय 334Cन तुमी कितें म्हणटात की आमी लॉंग लिजार घेतले म्हळ्यार फेर कॉम्पेन्सेशनान तुमकां विकते घेवंक सोदना तूं कोमुनिदादीक सांगता कितें लिजाचेर दी म्हळ्यार पयलीं तुमचे कडेन पयशे ना घेवपाक तांची जमीन ती पसून घेवंक सोदता ती लिजार घेवंक सोदता मागीर 70 आर्टिकल अमेंडमेंटाचेर वच 70 अमेंडमेंटाचेर कितें जाता स्पीकर सर गिव मी टायम 70चेर तूं कितें म्हणटा कोमुनिदादीक की बरे भशेन तुमी रावा लीज करा ना तुका डिसमीस करता ही धमकी आहा तुजे कडेन ताजे वयर वच तूं 50चेर कितें दिता तूं दोनदा तुका बसूंक दिता हांव तुका सगळें अलाव करता हें आमचें अलाव कर सो स्पीकर सर ही एक जी एज ओल्ड इन्स्टिट्यूशन आहा ताजेर एक आमी बील पास करून जापाच करून बचको मारतात हें हांव म्हणना हांव एक अनाडी म्हण धरया म्हाका व्हडली नॉलेज कोमुनिदादीची ना कित्याक हांव कोमुनिदादीचो तसो आय एम नॉट जस्ट अदर दॅन बींग MLA आय एम नॉट एनीबडी बीग असोसिएटेड विथ इट बट नो आय एम भाटकार म्हूण कोमुनिदादीचो न्ही हांव. बट द पॉयंट इज स्पिकर सर आज रिएक्शन हे पेपरांचेर आयिल्लें आहा. सो हांव एक मागतां आनी म्हाका दिसता बाबुशाक कोण तरी त्रासांक घालता ओगी तो इतलो असो ताकतीक करून बिल पास करपी मनीस न्ही. तो आसा त्या हातून कितें तें करपी. आनी स्पिकर सर हें करतना कोमुनिदाद स्टेक होल्डरांक कित्याक कॉन्फिडन्साक घेना. ते कॉन्फरन्स 3 ते 4 वर्सां जालीं जावंक ना. घेया बरें कॉन्फरन्स घेया करा आनी मागीर करा तुमकां जाय तें करा. आमी जाणा की आमी वी आर इन अ मायनॉरिटी आमकां खबर आहा. पूण जे भशेन आयच्या रात्यां सगळें गोंय केलें जप्त म्हणून अशें करपाक गरज ना. कितें तुमकां आमदार विकते घेतले म्हणून सगळें गोंय खावंक मेळटा. म्हाका स्पिकर सर हें कळना तुमचें गणीत. आनी हांव मुख्यमंत्र्या कडेन मागतां हें सारकें व्हडलें अशें इतली प्रॉपर्टी एक करूं नाका. सुशेगाद वच इतली फास्ट कित्याक. टेक योर टायम. हें स्पिकर सर सगळें कोमुनिदाद आवट हें आवट तें आवट अशें कशें जातलें. सुशेगाद घे.
Who oppose this bill introduced by Revenue Department because of पहिलूच amendment of Article 39 इथून मेन्शन केला की for the word prescribed in this code is changed to prescribed in this code and rules framed there under. स्पीकर सर कसले रुल्स हे आता तुमकां फुडें सांगता. पयलू म्हणजे आर्टिकल 327 हितून कितें घातला सर की 5 मीटर जो जागा आसा 5 मीटर दिवपाचो तो आतां 10 मीटर करता. फॉर एक्झाम्पल आतां आमी पळयतात मीन्स कोमुनिदादीची जागा आसा सायडीच्यान दोंगर आसा प्रायवेट प्रॉपर्टीज आसा. समज 5 मिटराचो 10 मीटर गेलो जाल्यार अकॉर्डिंग टू DCP तांकां रोड एक्सेस मेळटलो. कित्याक फाल्यां म्हणटले की कोमुनिदाद ना एडमिनिस्ट्रेटर आसा एडमिनिस्ट्रेटरा कडल्यान घेतले थंय रोड असायन करतलो आनी जी बिल्डर लॉबी आसा ती वाडत रावतली रियल इस्टेट जातलो. सो जे आमचे आदल्यान जाणट्यांनी राखून थेयल्ले ते खंय ना खंय काबार जातले. हो पयलो पॉयंट आसा. स्पीकर सर दुसरो पॉयंट आर्टिकल 334A हितून स्पीकर सर कितें दाखयला की पयलू जेन्ना जागा दिताले तो 1,25,000 जो अमावंट आसपाक जाय आसलो मागीर जालो 3,50,000 आनी आतां प्रोविजन केला की 15 lakhs दिवचे म्हण एन्युअल इनकम. सो हें जे एन्युअल इनकम आमी म्हणटा सो हें चेंज जायत रावले पिरियडिकली चेंज जायत रावले. 1980साच्यान चालू आसले आनी स्लोली तेंच्यानी चेंजीस करीत रावले. इन्सर्शन ऑफ 334A was done in 1985 and this was the start of amendment in article 334A and seen how person of goan origin is not been given a land. आयज कितें जाल्लें आसा स्पीकर सर की जे ह्या आर्टिकलान कितें मेन्शन केला कोण लँडलस. आयज लँडलस कोण लँडलस तो क्लियर कट ना. तितून तुमकां रीड करून दाखयता. Very interestingly, the landless explanation given in 1993 says neither the person or his or her suppose or minor child owns a plot of land or house in the state of Goa, and the word house includes a flat or apartment. म्हटल्यार कितें गोंयकार आतां कोणूय गोंयकार आसा तेजो आज्या पणज्या कडेन जावं तेज्या बापाय कडेन जागा आसा प्लॉट आसा. आमचो जो जेन्ना फ्रिडम फायटराचे प्लॉटाचे केले सेम घातलेले की गोंयच्या फ्रिडम फायटरांक मेळत भायल्यांक वयता. सो ह्या क्लॉजान कितें घातलेलें आसा की गोंयकारांक मेळपाचें ना कितलेंय कर हें सगळें भायल्यांकूच वयतलें. सो तेजेर घालपाक जाय आसलें की खंयच्या वर्साच्यान तांकां दितले. सो आयज प्लॉट समज आमकां गोंयकारांक जाय ते मेळपाचें ना. फुडें जेन्ना आमी वयता इनकम क्रायटेरिया जी घातल्या 15 लाख आसा 15 लाख समज आयज हाडले आनी तितून सेम रूल एप्लाय जाता की गोंयकारांक हें मेळपाचें ना. कारण फॅमिली आसा 3 जाण आसा 5 जाण भाव आसतले आनी ते फॅमिलीक समज आमी पळोवंक गेले तेंचो इनकम वाडटलो पूण भायरसून कोण येता आनी तेणें समज अप्लाय केलें नाल्यार तेका मेळटलें. हो कसलो जस्टीस. स्पीकर सर फुडें आमी जेन्ना पळयता 334C insertion of 334C is another way of capturing Comunidade land in partnership with the Comunidade to private players. As 334 सीन सेम सांगला की प्रायवेट बाकीच्या आमच्या कलिग्जान एक्सप्लेन केल्लें आसा की हे आसा जे सरकार कितें करता प्रायवेट ओनरांक भितर हाडटा. कोमुलदाद जी आसा ती एक सेपरेट बॉडी आसा आनी सेपरेट बॉडी चलता. पण आयज कोमुलदादीन चेंजीस जायत आसा आनी हाडून हाडून दुसऱ्यांक भायल्यांक हाडून भरता. हो कोड ऑफ कोमुलदाद बूक कित्याक लागून आसा? हे कोड ऑफ कोमुलदाद बुकान चेंजीस समज केली आनी प्रायवेट ओनरांक समज आमी भितर घेतले नाल्यार फुडें जी बिल्डर लॉबी आसा ती ऑटोमॅटिकली भितर सरतली आनी रियल इस्टेट जी लॉबी आसा ती खंय ना खंय तांकां चान्स पडटलो आनी ऑटोमॅटिकली गव्हर्मेंट जेन्ना जागा म्हणटा कोणी गव्हर्मेंट तांकां असायन करतले कोणी प्रायवेट ओनर येतलो प्रायवेट ओनर म्हणटलो आमी इन्वेस्ट करता म्हणटलो आनी प्रॉपर्टी फुडें वयतली. स्पीकर सर.
Because the honorable member is taking up the same issue which the other members have already raised.
तो
It is
स्पीकर
just a
सर
repeat of the
आमचो
same issue.
स्पीकर सर सब डिवायडेड जेन्ना प्लॉट म्हणटा म्हटल्यार इंडस्ट्री हाडटा इंडस्ट्रियल स्टेट करपाक लागून जावं हे आमचो प्लॉटिंग करपाक लागून. सो प्लॉटिंग कोणा करतले प्लॉटिंग समज केली नाल्यार बेनिफीट कोणा जातलो गोंयकारांक जावचीच ना.
स्पीकर सर तो विषय खंयच्या खंय व्हरता आतापर्यंत ते कंट्रोलान
Other people have already discussed it.
स्पीकर सर एकूच लास्ट हांव मागता
एकूच सांगता स्पीकर सर.
सर लास्ट मागता
पहिली जी गोष्ट आसा स्पीकर सर स्पीकर सर हांव एक सांगता स्पीकर सर स्पीकर सर बेनजी पळय सांगता
अंदाजी लागून आमकां
आर्टिकल
एक पाट रिकॉर्डा उरतले दॅट फर्स्ट टाइम यू हॅव टेकन बॅक वन बिल काय ना
स्पीकर सर
यू विल बी एप्रिशिएटेड
स्पीकर सर गव्हर्नमेंटाच्या अंडर आर्टिकल 5 कोमदीदार तेकाच खबर ना
मेजॉरिटी बट समथिंग एट लीस्ट यू हॅव टू लिसन.
स्पीकर
सगळे जात ते 7 जाणांगे सारखे ऐकना म्हणून यार हो सगळी बिल पास करा एटलीस्ट यू स्टिक टू दिस कम बॅक टू द
बिल कमिटीन घालचे ही आमची मागणी आसा.
आम्ही कसलो फायदो जालो स्पीकर सर प्लीज कन्सिडर डोंट टेक दिस बिल दिस टाइम विल डिस्कस इट फर्दर फाटी काय लॉस जायना तुमकां.
स्पीकर सर
इज नथिंग टू लूज कोणागे
सिलेक्ट कमिटीची
इट इज डिस्टर्बिंग एवरीथिंग. आम काळजा असो
टाइम उलोवपाक दिता पण आयकून तरी घे न्ही
आमी तू वर्सां आम सांबाळटाय
आयकून तरी घे न्ही पयलें तुका उलोवपाक टायम दिता
उलोवपा न्हू तू मान्य जाता म्हणटलो सगळे मान्य करतले पास करतले.
स्पीकर सर जे कन्व्हेन्शन तो सांगता इट इज इनकन्क्लुसिव्ह म्हणून तोच सांगता पूण अंडर आर्टिकल 5 ऑफ द ट्युटलेज गव्हर्नमेंट हॅज द पावर तेन्नाचे आर्टिकल वाचून ताका पळोवं स्पीकर सर. दुसरे जो तो आमचो बाब सांगता आमचो विरेश बाब सांगता स्पीकर सर पयली सुवातेर जे डेव्हलपमेंट प्लॉट आसा पळय ते डायरेक्ट ना कोमदीदाराक जाय जाल्यार ते धाडटले कोमदीदाराक जर नाका जाल्यार कोण धाडटले स्पीकर सर. व्हेरी क्लियर आसा 334C वाचपा लाय ताका स्पीकर सर. तिसरे गोष्ट जी आसा तो 337 सांगता स्पीकर
सर तो बरतेक काय समजना तो बिस्तो उलयत रावता आनी आर्टिकल 5 ट्युटलेज म्हणून तू कोडा स्पीकर सर. This topic of serious concern. It is not PWD.
कसले serious concern?
Speaker, तू किती बोलायलात आता सदाजी? And we will listen. You understand Article 5? सांग म्हाका. Tell me the meaning of it.
सिलेक्ट कमिटी धाडचे बिल.
एस्कोन मरे एकूच तू. Why you have to interfere in everything? Everywhere you want to interfere. Don't interfere.
Law minister, so I have to interfere.
No, sir, this is not going to be allowed.
Speaker sir.
If you don't know the topic, let him not talk about it.
Who said I don't know the topic?
Here,
Mr. Venji.
this is not going to be allowed.
ऐकून तरी घे बस.
स्पीकर सर
मुख्यमंत्री उलयात.
वेंजीन थोडोसो म्हाका दिसता कंट्रोल करपाची गरज आसा. बींग अ लॉ मिनिस्टर ताणें पळयला ताणें वाचला तो एक्सप्लेन करता ताका तेजेर कितें सांगपाक जाय आसा जाल्यार ताका फ्रिडम आसा. तेणी क्लियर कट जेन्ना सांगला ओके तेजेर एक्सप्लेनेशन कितें दिवपाक तेणी परत जाय जाल्यार विचारचें. ताका रायट ना म्हणपाची गरज ना. स्पीकर सर आता पळया देर इज अ नो मेन्शन इन द कोड वेर देर इज मेड दॅट अमेंडमेंट इज टू बी प्लेस्ड इन अ कोमुनिदाद कन्वेन्शन. म्हाका दिसता एडवोकेट काल्लूस बाब हेजेर एग्री जातलो. इज एग्री रायट. नाव एकूच मिनीट. आता फक्त कशें आशिल्लें रिगार्डींग दॅट प्लॉट आमचे हितूर फक्त एकूच म्हणणें आशिल्लें प्लॉट दॅट वीथ कन्सर्न म्हणजे तांकां जर जाय जाल्यारूच धाडटले ते नाजाल्यार धाडचे ना. हितूर एकूच फक्त एकूच विशय आसा जो प्लॉट. एक मिनिट
In every department there is always one crooked guy, no? So everywhere there is always somebody.
ऐकून तरी घे न्ही.
एक्सप्लेन ह्या पूर्ण बिलान एकूच विशय आसा, ह्या पूर्ण बिलान एकूच कॉन्फ्लिक्ट विशय जो दिसता म्हाका दिसता एडवोकेट कालूस दोज बेटर, म्हणजे फक्त हितूरले जे प्लॉट डेव्हलपमेंट करपाक जाय आसत जाल्यार आनी इन केस इफ दे नॉट हॅविंग द फायनान्शियल तांच्या कडेन जर पावर पयशे ना, इन शॉर्ट पयशे तेंच्या कडेन ना, तांकां जाय जाल्यार ते प्लॉट डेव्हलप करपा खातीर गव्हर्मेंटा कडेन धाडून दितले परमिशनाक प्रायवेट प्लॉट डेव्हलपमेंट आमी करता म्हणून, हितूर गव्हर्मेंट इंटरफियरन्स करिना. एज फार एज बील जे म्हाका समजला तितून तांकां जाय आतां प्रायवेट डेव्हलपरा कडल्यान डेव्हलपमेंट करून घेवपाची, ते परमिशन घेतले तांकां आमी करता म्हणून आनी ते परमिशन घेतले.
Speaker, I don't want to interrupt, but just since the Chief Minister has directly said to
कितेंय
me,
उलयता बाकीचे तितूर घेना.
Just one small thing.
Yes, you can. एक मिनिट, at least let Advocate Kalu explain.
one thing, let me make it very clear, though we are in opposition, I don't agree with that argument which many people have made. 652 comes into the code for the purpose of debarring the government. I myself have argued these matters in the High Court, and in fact there was even an argument to say that who made the code should amend the code, and I don't agree with that theory. The code was made by Portugal, you can't go to Portugal to amend the code. I don't agree with this. Secondly, I have succeeded myself appearing for the government that the state government has the power under entry 18 and 32 of list 2 of the 7th schedule of the constitution to amend the code of Comunidade. That judgment was never carried in challenge, and it was subsequently amended, and no one ever questioned that judgment ever. So that is the law of the land. So the state government has. But now on the second part, Article 339A, I understand that you all are thinking one thing, that it is when the Comunidade is financially weak. But those words are not there.
Okay, what word you want to introduce?
When the Comunidade which is financially weak, only introduce that.
We'll introduce.
That's it.
Yeah, we'll introduce.
We'll introduce. Minor changes.
With minor changes, whatever the suggested by Advocate Kallus.
Right.
Yeah, we'll introduce. Chalo.
आता विधेयकाचे दुरुस्त्यो सकट सेक्शन 6-7 सभागृहा मुखार मतदान घालता. जेका मान्य आसा ताणें हय म्हणचे, जेका मान्य ना ताणें ना म्हणचे. हय म्हणटाचे म्हणणे मान्य जालें, हय म्हणटाचे म्हणणे मान्य जालें. विधेयकाचे दुरुस्त्यो मान्य जाल्यात. प्रश्न असो आसा, कलम 2 ते 8, कलम 1, सेक्शन 6 and 7 अधिनियम सूत्र एज अमेंडेड आणि प्रदीर्घ मथळ्याचो विधेयकाचो भाग जावचो काय कितें? जेका मान्य आसा ताणें हय म्हणचे, जेका मान्य ना ताणें ना म्हणचे. हय म्हणटाचें म्हणणे मान्य जालें, हय म्हणटाचें म्हणणे मान्य जालें. कलम 2 ते 8, कलम 1, including section 6 and 7 as amended अधिनियम सूत्र आणि प्रदीर्घ मथळ्याचो विधेयकाचे भाग जाल्यात. महसूल खात्याच्या मंत्र्यांना ते विधेयक मानून घेवपाचो प्रस्ताव मांडचो.
Speaker, sir, I request to move that Bill number 17 of 2023, the Goa Legislative Diploma number 2070, dated 15/4/1961, Amendment, Bill 2023 with amendments to clause 6 and 7 be passed as amended.
प्रश्न असो आसा,
6, 7 and 8.
येस,
6, 7 and 8.
6, 7 and 8 be amended.
With amended, yeah. With each suggestion.
6, 7 and 8.
8, 6, 7, 8.
Yeah.
प्रश्न असो आसा, विधेयकाक दुरुस्त्यो सहित 6, 7, 8 मानून घेवच्यो. जेंका ते मान्य आसा ताणें हय म्हणचे,
Yes.
We would like
मान्य ना
to
ताणें
go.
ना म्हणचे.
Yes, division mark by the Speaker, sir. We would like to go for a division of votes on this because we cannot do amendment to the code like this. It is not about bringing an amendment, whatever Advocate Kalus has said. It is about you cannot carry out these amendments like this in this assembly hall. So we would like to go for a division of.
Marbe.
येस, आता विधेयक सभागृहात मुखार मतदानाक घालता. जेंका विधेयक मान्य आसा ताणें उपकार करून उबे रावचें. जेंका विधेयक मान्य आसा 28.
Take People should know. You are standing or you are
No,
sitting?
Article
you cannot
70,
discuss.
Article 70 that. I had an amendment to
This is
Article
what?
70.
You sit down or you stand?
हातांनी
You
कितें
should know.
Yes.
हातांनी कितें करपाचें
Those in favor, the bill 28. ज्यांका विधेयक मान्य ना ताणें उबे रावचें.
आता विजय हिंगलो.
No, I said Article 70. I was asking for that. You're taking
Kitare?
over the Comunidade.
जालेलें आहा.
Today Goa should know that for Comunidade how many MLAs are
ज्यांका
standing.
विधेयक मान्य ना अशें
जालेलें आहा.
7 जाले. 6.
Oh. एकलो ना.
जालेलें आहा.
Yes. Ah, yeah. जालें न्ही. येस फुडें वचया आमी. हय म्हणटाचें म्हणणें मान्य जालें. हय म्हणटाचें म्हणणें मान्य जालें. गोवा विधिमंडळ डिप्लोमा नंबर 2070 तारीख 15/4/1961 दुरुस्ती विधेयक दुरुस्ते सयत 2023 मान्य जालात.